my best not to repeat myself, is to not bore all of you. So we will try and get to your question. If we don't read it in the exact configuration that you sent it, it's because we've addressed it in a slightly different format. Again, we've gotten this question several times already. Is this presentation available? Yes, the PowerPoint is posted on the website. There's the link right there, that very first bullet. And you can simply go to atf.gov and just type in stabilizing braces in the search bar, and it will take you to this page that has not only this presentation, but also a long list of frequently asked questions. All right, let's go ahead and get started. First question. If a customer owns a micro conversion kit, which under the new rule would be classified as an SBR, as well as multiple pistols that go into the kit, how is that taxed? Would they need to register the MCK, one of the pistols, or all of the pistols? So a lot in that question. Let's talk about the micro conversion kit first.
The micro conversion kit by itself is an accessory or a part. It is nothing that we are going to regulate. To go further into the question with multiple, we're going to regulate the firearm, and it's a firearm to that conversion kit. It is not all of them. It is that particular firearm to that particular kit.
Okay, next question. In the next 120 days, are gunsmiths able to work on customers' pistols with a stabilizing brace if the work is done the same day, meaning is not entered into the bound book if the customer has not submitted a Form 1 yet?
You would have to submit a Form 1 to register within the next 120 days. Once that Form 1 is submitted, you can take it to a gunsmith and have it worked on while you're present at that gunsmith in order to avoid the transfer process under the ATF Form 4.
Okay, next question. What do I do when a customer brings in a PMF AK pistol? I think we're going to need more information on that. I'm not sure what you're trying to get at. So if you submitted that question, if you could submit another one that provides a little bit more detail there so we could answer that, that would be great. Okay, next question. If the SBR tax stamp is obtained today with the brace, are individuals able to add a traditional stock to the firearm at a later date?
Yes, once it's registered as an SBR, it can be, an SBR is an SBR. Traditional shoulder stock can be added, and I'll go ahead and cut off the next question will be asked. A vertical foregrip could also be added to the rifle.
Okay. Next question. Are there any examples of commercially available braced firearms that are not now considered SBRs?
And we've covered this one a couple of times. There's an example of one in the final rule. We have seen multiple stabilizing braces designed to stabilize one hand firing and they do not provide surface area to shoulder to weapon. However, most of these, if not all of these, are not marketed because of the popularity of the current ones.
And you can find the final rule reg text on our website. Again, if you just go to atf.gov and type in stabilizing braces, you can find it there. Are there any other websites they can go to find the final reg text?
They can visit the Federal Register website, which is where the final rule was officially published.
Great, thank you. So the next question deals with trusts. So we've got a lot of questions on trusts. My state does not legally require assignments into a trust to be notarized. How do we prove the rifle was owned by the trust if the assignment is not notarized?
It doesn't require that the document be notarized. That's, again, trust requirements are determined by the state. You just have to show sufficient proof that the property was held by the trust on the effective date of the rule. So whatever your state requires for showing or demonstrating the property held by the trust, that's what you're going to have to show. A notarization that's noted in the reg is just one example. It says, for example, notarized statement because a lot of states require it to be notarized.
Okay, next question. If the ATF has my fingerprint card from my FFL application on file submitted less than 6 months ago, do I have to submit a new fingerprint card with the Form 1?
Yes.
Okay. If a person submits a Form 1 but has not received it back after the 120 days is over, can they take it across state lines without notifying the ATF?
No, you would still need to comply with the federal law, which is 922A4, in order to transport it interstate. So you would need the Form 1, you need to submit it, and you need to get it approved before you transport it in and file the Form 23.
Okay, next
Sorry.
question.
Form 20, I'm sorry, wrong form, Form 20.
If a stabilized brace pistol in my possession, but I want to transfer it back to my FFL business to do a Form 2 on it rather than filling out a Form 1 as an individual, what would be the process for that?
You would actually couldn't do that. You're going to have to register it. If you want to do it tax exempt, you're going to have to register it on a Form 1 to yourself because you're currently the possessor of that firearm. After you do that, you would do a Form 4 back into your inventory. You would not, you could not transfer that firearm into your inventory to register it for the first time on a Form 2 because your FFL does not currently possess it. This only deals with this tax deferment or forbearance only is for people who currently possess the firearms.
And possessed it as of January 31st, correct?
Correct.
Once registered it says once registered, Form 1 approved, these SBRs do not need the owner's name, city, and state engraved on it if it already has one from the original manufacturer, including multi-caliber markings for the manufacturer. Correct. Yes, that is correct. You do not have to, whether you are registering it on a Form 1 or a Form 2, you do not have to add any markings if it already contains all the required markings. So from the original manufacturer, their name, their city and state, model, caliber, if such has been designated. Next question. What do we put into box 4H of the Form 1 that should be engraved on the NFA item? So again, the markings are coming from the firearm itself. You do not need to add any markings. Okay, next question. When determining if a braced firearm is similar to the same SBR, Roni versus MCK, Honey Badger pistol versus SBR, the rule states that they are looking for how similar the weight and length of pull are. How much difference is required to qualify as a pistol?
We don't have a set difference. It's going to be taking a holistic approach looking at the firearm. And if the characteristics are similar in design, where essentially and in place of a stock, you have a stabilizing brace, which allows the weapon to be fired from the shoulder. Even if it's a shorter length of pull or it makes the weapon slightly weigh less, then you have a short barrel rifle.
Okay, the next question has kind of two parts, so we'll address them separately. The first one is, do FFLs have 120 days to comply? So everyone that's currently in possession of one of these as of January 31st, so you possessed it as of January 31st when the final rule was published in the Federal Register and became effective, you have 120 days to pick one of those 5 options to comply with the final rule. That date is May 31st, so that applies to everyone currently in possession. The question then goes on to say, the rule says the rule is immediately effective and that the department may seek to enforce NFA's requirements with respect to any new making or new transfer. Then goes on to say, for purposes of the Congressional Review Act, however, the department will wait to actually initiate such enforcement actions for at least 60 days from publication of the rule. So this was more of 3 parts. The second part that talks about with respect to any new making or new transfer. So as of the 31st, January 31st, anything that was in your possession, you have the 5 options to comply within 120 days. Anything new that is made starting February 1st, anything new that was made would have to immediately be in compliance. So there is no 120-day compliance. If you make a SBR today, you have to follow all of the NFA requirements. You have to submit the appropriate forms in order to be in compliance. So this is only for things that were already in the person's possession, nothing new, and no transfers of those items. To be clear, if you have one of these items that is now considered a short barrel rifle, you cannot transfer it to anybody for any reason, because that would be considered the transfer of an unregistered NFA weapon. Now, the part about the Congressional Review Act.
So it says that enforcement will not begin for 60 days. That doesn't mean that the activity that you are proposing is going to be lawful. It just means no action would be taken against you for 60 days. So, for example, if a transfer, an unlawful transfer occurred 5 days into the rule, no enforcement action would be taken for another 55 days, but then enforcement action could be taken after that 60-day time period has expired.
Okay, next question. As an FFL, if a customer brings in an SBR without a stock or brace and is trying to sell it as a pistol, are there going to be any way to find out if that gun is in the NFA registry?
So there's multiple ways to do it. First of all, you could ask the person whether or not it's registered. Second of all, if it in its current configuration as it's being offered to you, it is not a short-barreled rifle. It doesn't have a shouldering device. It is an AR pistol. So even though they have registered the frame or receiver, they have essentially removed the offending features or the features that would make it subject to enforcement of the National Firearms Act. You certainly can ask them. You can ask them if they've done it, and if they want to sell it and then remove it from the NFRTR, because they have a registered firearm in their name, they should notify NFA branch and tell them that they are removing it from the purview of the NFA, and NFA branch or division can actually take it out of the NFRTR and it will no longer be registered. But if it's being offered to you as a pistol and it doesn't have a shoulder stock, then you can certainly accept that firearm.
Okay, next question. If we have an inbound shipment, we might not know what's in the box until we open it. So it would be difficult to refuse the shipment until we open it and see what it is. By that time, the UPS, FedEx driver would be gone. So now I'm holding a pistol braced firearm that I received after January 31st. What do I do with it? You would need to turn that into ATF.
You should, the intent of this is that people that are in current possession of these short-barreled rifles as of January 31st can register it. That was yesterday. So if you receive it today and you open the box, you need to comply with the rule with the other options other than registration. That's either remove the brace, remove the barrel, destroy it, or turn it in. That's it. Don't open the box if you can avoid opening the box and sending it back, return to shipper if you think it's a short-barreled rifle.
You would handle this the exact same way you would handle any NFA firearm that was sent to you without registration papers that you weren't expecting. If you open it up and there was an AOW or a machine gun or something of that nature, you would handle it the exact same way. This is a short-barreled rifle that's unregistered.
Okay, next question. Does the ATI P4 7.5 pistol with buffer tube need to be registered?
We'll come back to that one.
Okay, and some of these technical questions, would you like them to submit that question to you?
Right, that's a better specific question for fire_tech@atf.gov.
Okay, next question. In the recent article, ATF stated the braces as a new rule. What's the difference between the terms rule and law?
So we're not going to do a legal discussion here, a law school class, but you have, of course, statutes that are passed by Congress. Congress then gives authority to the agencies to interpret those laws where it's not necessarily clear. Oftentimes it's expressly in the passing of the statutes themselves. They authorize regulations or regulations that interpret it, and that is required to go through notice and comment. That was it for this particular regulation. That was done, as you well know, it's an NPRM followed by a comment section or a period at which point the final rule was drafted. But other than that, you can clearly Google it. We don't really want to go into too much on that.
Okay, next question. Is a pistol style buffer tube required for firearm to be a pistol, or can a 6-position buffer tube with no attachment be used on a firearm and it be considered a pistol?
The multiple position buffer tube for an AR pistol can be used. We're not eliminating that from there. We understand it's for the cycle of operations, whether it's a AR pistol buffer tube or a multiple position buffer tube for an AR pistol.
Okay, next question. We've gotten this several times. When filing the E-Forms 1, does a person have to take a picture of the whole rifle or just a receiver?
It's optional to submit a picture.
Okay, so submitting a picture of the firearm is not required.
Correct.
Is it required in a Form 2?
No.
Okay. All right, next question. So this person is referring to the trainings yesterday. They said in Tuesday's seminar, cheek welding an AR receiver tube was deemed allowable by the panel. This seems in direct conflict with the sight, scope, eye relief consideration, as both positions are similar and cheek welding would make variable magnified optics usable in a pistol configuration. Can you clarify?
Yes, I can clarify. Again, we are not getting to category 2 with any of those 6 factors unless we meet category 1 first, which would be a surface area provided for shoulder firing. Once we meet criteria 1, we would then look at the other factors within 2. So with that question, if it is cheek welded, we're not having surface area provided for it to be shoulder fired. So we would not get to category 2.
When determining the manufacturer's intended use, is this the firearm manufacturers, the accessory manufacturers, or both? For example, if ATF decides the SBA-3 was designed to fire from the shoulder, will that affect a manufacturer using them?
We're not going to make an evaluation about whether or not a particular item or a part is in violation. What we do is we look at the firearm itself. We evaluate the firearm and the objective design features of the firearm. Those are laid out in the rule. It talks about those features that indicate what the intent was, and those are laid out quite clearly, surface area, and then moving to category 2, as they just stated, where we look at other things that would indicate the intent, such as eye relief, overall length, overall weight, length of pull, those things themselves. But the ATF has made no evaluation of an individual arm brace itself, sitting by itself. Under this rule, we are looking at weapons as they are currently configured, or as they are presented to us.
Okay, next question. This is dealing with imports. Can you touch on the 922R part of this rule?
So we saw a lot of chatter on the internet about this. If you have a firearm that you think may not be 922R compliant, the possession is not unlawful. It was the making itself. You are allowed to register it. You're allowed to do any of the options that are available to you. 922R is not consideration for a possessor of these, and those are the ones who are going to register these or remove the arm brace. Or any of the options that are available under the rule. So those pistols, you don't have to turn in, they don't have to be destroyed. I've seen multiple suggestions on the internet. That's just not accurate.
Okay, next question. Worksheet 4999. Can you talk about that? Is that part of the final rule?
No.
So that worksheet is not part of the final rule, thus it is not being used to determine whether or not something is a short barrel rifle, correct?
No, the objective design features that are listed in the final rule were pulled from the worksheet form 4999, but the worksheet form 4999 is no longer being used to make classifications.
Okay. So after form wanting a pistol with a brace into a SBR, can a stock be attached?
Yes, a shouldering device is a shouldering device, whether it's a brace or a manufactured stock. Once it has been registered, it is a shouldering device. So yes, you can put whatever stock you'd want onto it.
Okay. Next question, we've gotten this several times, so we definitely want to clear up this misconception about the 88-day processing. The question is, if your background check hasn't been processed in 88 days, the Form 1 is automatically denied. What options are available for those types of people? So can we clear up this misconception?
The 88 days is an FBI process that they use for researching an open background. That is not an FBI policy. That is not an ATF policy. It's an FBI policy.
So there is not, the Form 1s are not automatically denied after 88 days of processing. Is that correct?
That's correct.
Okay, The next question says, do you have to destroy the brace or make it permanently non-attachable to the firearm?
No, the concern here would be constructive possession, which we really haven't talked about much in this training session. But no, if the brace is removed and even if a 6-position adjustable buffer tube, you would be okay as long as you divest yourself of the brace. In other words, if the two items cannot be stored together, a example would be if the firearm is placed in a drawer and the brace was placed right with it, you would have constructive possession and you would still have a short barrel rifle in that case. So while it's an option to change out the 6-position into a rounded pistol buffer tube, it is not required. However, you need to take into consideration constructive possession and treat the brace just like you would treat any other shoulder stock.
Okay, next question. Does the term individual include registration by an entity, limited liability company or corporation or trust?
It includes any person, the definition of person under the Internal Revenue Code. So yes, the answer is yes. The trust, the limited liability companies, the corporations, those entities, if they are a person under the Internal Revenue Code, they can register it.
Okay. Page 18 of the presentation seems to show an AR pistol with pistol buffer tube is acceptable. Please verify.
Yes, as stated before, the receiver extension or buffer tube on most AR type pistols, there are some upper assemblies that do not need the rear buffer tube, is acceptable because it's necessary for the cycle of operations for that pistol.
Okay. The Form 1 has to be submitted for braced firearms in inventory before May 31st, 2023, or must be approved before May 31st, 2023. It just, if you're choosing the option to register these items, you just have to submit the appropriate form, the Form 1 or the Form 2, depending on how you're classified. That has to be submitted prior to May 31st, 2023. It does not have to be approved prior to that date. Okay, next question. What do we do with the quote others that are non-NFAs? I'm not. Yeah, I think you might be talking about some state laws, so we can touch on that briefly about state laws.
So if a firearm, say an AR type pistol, has a secondary grip attached, if it's under 26 inches, then it's going to fall into the any other weapon category, being concealable, capable of being concealed on a person. However, a lot of others, such as the XO26, is specifically built to be over 26 inches and not be a pistol because it has a secondary grip. These firearms would remain the same in that configuration. However, when a stabilizing brace is added, it will likely fall under the purview of this final rule and would need to be registered as a short-barreled rifle. If it cannot be registered in your state as short-barreled rifle, then removal of the device would take it back into the other category.
The next question, the $200 making tax is being waived for the Form 1 submission, but will the individual be required to pay the $200 tax stamp when submitting the Form 4? So the tax forbearance is for current possessors of these items. It will allow them to register what they currently have in their possession as of January 31st without having to pay the tax. Any future transfer will be subject to the tax. All right, next question. In a pawn shop setting, if a customer is redeeming an AR pistol with a brace and contains a magnified scope, can we remove the scope and return the scope to the customer? And what do we do with the brace? So you cannot return a firearm that is now considered an SBR in its current configuration, because that would be considered the transfer of an unregistered NFA item. So your options would be, if you are dealing with a pistol that has a stabilizing brace that under the final rule is now considered a short barrel rifle, you have to either remove the brace and then you could transfer the pistol back to them. You could attach a 16-inch or longer rifled barrel and return it to them. really, you have all 5 options. You would obviously want to contact the customer, but you cannot, the bottom line is you can't return it to them in its current configuration. That would be considered the transfer of an unregistered NFA item. Okay, next question. How does this affect law enforcement agencies purchasing from a company that is a registered importer?
Well, so law enforcement agencies, if you have them in your current possession and they are legitimately law enforcement for on-duty purposes, you can either register them on a Form 10, which you could do anyways with an unregistered NFA item. Keep in mind the ATF Form 10 restricts further transfer, or you can register them tax-free on a Form 1 to the law enforcement entity. Now, if they are not for law enforcement purposes, let's say they are for individual duty or an individual officer, those must be done on a Form 1. And register it on Form 1.
Okay. Next question. What is the actual number for what was called acceptable length of pull?
Again, that varies per weapon platform. Again, we're not going to throw out a number such as 13.5 and say anything below that is not a length of pull for shoulder fired weapons. These length of pulls often go down to as low as 10 inches or so. And we provided a chart in the final rule giving examples ranging from 10 inches, I think, up to 18 and a half inches in some scenarios. We'll be comparing apples to apples.
Is there documentation that will be provided that confirms I have submitted a braced weapon as an SBR so that I can show as proof before it is approved?
Yes, as soon as you submit your form, you'll get an email shortly thereafter that will have the submitted document with the submitted watermark across it.
Next question deals with the effective date of the final rule. The person says, is that close of business 1:31 or 12:01 a.m.? It was the time that the final rule was published in the Federal Register.
I believe it's 12:01. It became effective immediately after 12 midnight by a minute or two. But
I think it would be through close of business or through the end of the day. But is that what they were asking?
no, so the effective date was the date of publication, and it was 12:01 of the date of publication.
You would have to register.
Yeah. Are we talking about the effective date of the rule, or are we talking about?
We're talking about the effective date of the rule.
Yes, that was January 31st at 12:01 a.m.
How does the stabilizing brace ruling apply to shotguns and pistol grip firearms?
So the final rule specifically classifies rifles. It does not amend the regulatory definition of shotgun. However, there is language in the final rule explaining, one, that any previous classification of a smoothbore firearm with a stabilizing brace is hereby superseded. And two, it basically explains that a smoothbore firearm cannot be fired with one hand without meeting the AOW definition, and therefore is likely a short barrel shotgun based under the same criteria.
Will this Form 1 require the formalities of other SOT applications, fingerprints, passport style photo, etc.? So if you guys could explain what's required.
So the Form 1 is going to have the same requirements for everybody, with the exception of a qualified dealer, and that's somebody with the FFL SOT. Everybody else is required to submit their fingerprints and photos.
Okay, next question. What is the NFA plan to process the millions of submissions and the expected time frame?
There is no expected time frame. We are using internal resources to process those applications.
How should these be categorized on the 2023 AFMR report? So that's a great question, and one we got yesterday as well. We are on adding that to our frequently asked questions, and we should have that posted early next week. Is there a limit to how many can be submitted with a free stamp?
So there's no limit to those that can be submitted. However, they must, as we've said repeatedly, they must have been possessed on the effective date of the rule. So if you currently possess an arm brace equipped firearm that would be a short barreled rifle under the new regulation, then you're allowed to, within the next 120 days, submit a Form 1 without paying the $200 tax. Those are only for ones that you currently possess. So you can't acquire more and file tax exempt. If you would like to acquire more, equip them with an arm brace, you would submit a Form 1, you'd pay your $200 tax, and after you received approval, then you could add an arm brace to it and create another firearm.
Okay, next question. If a customer brings an AKM PMF that they manufactured as a pistol with a brace, can that be registered before I work on it?
Yes, the only difference between a PMF and a standard manufactured by someone with licenses, it will need markings applied in order to be registered into the NFRTR. But yes, if it meets the same criteria as any other firearm covered by the final rule, then yes, it could be registered.
If someone brings an SBR for service, do they have to stay present while it's being serviced? So I think this is again talking about if someone brings in a short barrel rifle for gunsmithing activities, that short barrel rifle, first of all, has to be registered to the possessor, and then it can be provided, it can be given to the gunsmith only for gunsmithing purposes, but it does have to be registered to the current owner. Next question. What happens if someone submits a Form 1 and it is ultimately denied before or after the 120-day deadline? So that depends on why it was denied.
Yeah, I think if it's a clerical error or something like that, you would resubmit. If it's a disapproval based on state law, you're going to need to contact your state law to see why it's disapproved or under what law, for what reason. If it's disapproved because you're a prohibited person, obviously you can't possess that firearm. So you may not be able to possess the firearm under state law or because you're prohibited. At that point, you would need to take advantage of the other options in the rule and go forth with that.
Okay, next question. Can multiple SBRs be registered on a single Form 1 or must there be one form per weapon?
One form per weapon.
Can we sell the brace that we remove from the guns as a separate purchase as dealer?
Those are just parts. You can do what you do with all of your parts. So if you want to sell arm braces, people can buy the arm braces from you. They can submit Form 1s for application to build and pay their $200 tax, and they can create SBRs. They can add it to rifles with barrel lengths of excess of 16 inches. They could buy parts from you the way they would normally do. There's no regulation of the brace itself. Again, like we said before, we're looking at the configuration of the entire weapon itself.
Okay, next question. Will firearms like the CZ Scorpions and Charles Daly Pac-9 that do not come with braces and function with no rear devices be affected?
Not unless a rearward attachment is attached or stabilizing brace is attached to the firearm, but by themselves, they are pistols and how they are imported into the country.
Okay, next question. This deals with FFLs in the process of transferring a pistol with a attached stabilizing brace that is now considered an SBR. If the transfer has not occurred, it is now, the final rule is now effective, so you cannot proceed with that transfer in that current configuration. That would be considered the transfer of an unregistered NFA item. So you will need to take one of the other options. You can still transfer the pistol by itself if you remove the arm brace first, or you can attach a 16-inch rifle barrel and thus it's now a rifle and transfer it to the customer in that configuration. But you cannot transfer it, even though you possibly started the 4473 in the background check prior to the effective date of the rule. You cannot transfer it because it is now effective. Must an individual's brace be removed during the waiting period for the Form 1 approval? No. So again, that's one of the compliance options. Once you submit that Form 1, you are in compliance. You do not have to, it's not a matter of getting it approved within that 120 days. It is simply submitting it. You can keep it in that configuration. If we have a rifle caliber pistol logged into the logbook as a pistol, and I change the barrel to make it a rifle, how do we log that change in the official logbook?
It's registered as a pistol in your A&D records. You would log it out to yourself, log it back into yourself, and change it to a rifle.
If we choose to remove the short barrel and get a 16-inch barrel and no barrels are in stock at the moment, can we just remove the barrel from the rest of the firearm until we procure a replacement 16-inch barrel?
Yes.
Is the AK-47 pistol such as Draco's without a brace, is that still okay?
Yes, the final rule affects firearms with attached accessories, components, or other rearward attachments.
Is there a plan to release a way to bulk form ones, or are people that own multiple have to do one for each firearm?
Have to do one for each firearm.
And that question also asked about photos. Again, we answered that before, but photos of the firearm are not required. If you choose to upload a photo, it is recommended that it be a close-up of the markings. If the Form 1 is denied for a clerical error and it is after the 120 days, is there a way to resubmit it tax exempt? So again, the question is, if a Form 1 is denied for a clerical error and it is after the 120 days, is there a way to resubmit it tax exempt?
Paper.
Okay. And that is all the questions that we've gotten. Again, we've done our best not to continually answer the same question. Hopefully, we got your question answered. If for some reason we did not answer your question or you have follow-up questions, please look at the screen in front of you. You can submit those questions to fipb@atf.gov. If you have a question on a particular firearm or a specific configuration of that firearm, you're going to want to email fire_tech@atf.gov. And again, this presentation is available on our website, atf.gov. You can go type in the search bar, stabilizing braces. In addition, all of our frequently asked questions are on there as well. That AFMR question will be added by early next week. That is it for the training. Thank you all so much for joining us.